What is an enduring power of guardianship, and why would I need one? Greetings, my name is Rick Ward, and I'm a retirement coach and inspiring generational influencer at Your Journey Transitions. Come have a look over my shoulder as I meet with my estate planner, Catherine Lynch of Cariad Legal, as she explains what an enduring power of guardianship is. And then observe as I have my enduring power of guardianship drawn up. The purpose of this video is to provide you with a visualization of what such a meeting would look like and to prepare some questions so when you go to meet with your advisor in your locality, you'd be better prepared, and that whole meeting would be more productive and probably cost effective. Now let's have a look at that meeting in progress.
Yeah, so what I say to people is the will is obviously only looked at when you pass away, and that's the only document that's relevant once you've gone.
So
these documents are null and void once you pass away. But while you're still alive, you've got the power of attorney, power of guardianship. And I will stress, as I always do anyway, but these documents are state specific.
Right. And
obviously that extends to, it'll be different again in the States and in all other jurisdictions. And it's not ideal. It would be great in Australia if we had uniform laws across all of the states.
So even in Australia, these documents change?
They're very different. And so unlike a will, so I can very comfortably draw up a will, and I think I said to you before, I'd be comfortable drawing up a will and be comfortable that it would be valid in the UK, for example,
right.
And certainly within all of Australia. These documents they're from a statute. So they're very structured, and you have to basically follow how it's set out in the legislation. There's not a lot of room to just make up your own stuff with these. With a will, you can kind of play around and be quite free with the content to an extent, of course. With these, you have to stick to what the legislation sets out. So what I do here, I have done Queensland powers of attorney, and those documents are different because they cover both the medical and the financial side of things, and other states also they refer to them differently as well. So in Victoria, they talk about a power of attorney and a medical power of attorney,
right?
Which I think that's really good. It makes more sense. Mm-hmm. We like to be different in WA. We refer to a power of attorney and then a power of guardianship, which confuses people because people often think of guardianship of their children, which isn't the case. Guardianship of children is addressed in a will, and it's the only place you can address guardianship of children. So just to get that out the way.
Now your Advanced Health Directive, now is that a Commonwealth thing? So here your guardian, is the power of guardianship going to cover that? I don't need that because they can make those decisions for me?
So
that's not what we would
my
call it
understanding of and what we call, I think in the US they're referred to as living wills.
They do.
Yeah.
And here in WA anyway, I heard of it.
Advanced Health Directive.
Right, that's
yeah.
right.
So there's a hierarchy. The Advanced Health Directive sits at the top, and it will overrule anything else. But my advice, this is the way I operate, I recommend that people have an enduring power of guardianship. So that's giving somebody else the power to make all of those medical decisions for you and lifestyle decisions. So we're not just talking about whether or not to switch off the life support machine. We're talking about which particular care facility to put into.
Yeah, that's important.
Yeah, all of that sort of stuff right through. If you're giving somebody that power, obviously hopefully that's going to be somebody that you trust, that knows and understands the type of person you are, your values, the types of things you would want. It makes sense to have that person able to make those decisions and leaving it at that, in my opinion. An Advanced Health Directive is where you set out what you want to happen. If this happens, I want this to happen.
Right.
I'm not a medical professional. Very, very few of my clients are medical professionals, so I don't feel comfortable drafting up what I see to be really very medical, technically very medical, the instructions that you'd put in that type of document. So I recommend my clients go and see their GP.
Yeah, there's a template for doing the forms, but it says on there to give medical advice or legal
Yeah.
advice. So I guess the real distinction I'm making just now, just struck me,
Yeah.
is that the enduring power of guardian is I'm trusting somebody else to make those choices for me.
Yeah.
But if I'm really particular about something and I want my
Yes.
need, I want to follow to the letter, then I'll do the advanced health directive, and that sits on top of the other one, so that has
That's
stepped
correct.
forward.
And the only time that I've seen a justification for doing that, like a real, yeah, we will do that, we'll put that in place. We had a husband and wife, and of course they were happy to name each other in those capacities, but the wife, so the husband was happy for her to make all decisions. The wife was adamant that under no circumstances would she accept a blood transfusion.
Right.
However, her husband didn't share her beliefs.
Right.
And she knew that if she was in a position where she needed blood, he would say, give her blood. So that's a very clear example.
I think it's very common. That's what I hear the most.
Yes.
Okay.
Often though you've got, married couples that, for religious reasons, for example,
Right.
they might both share the same beliefs. This was one where, they didn't share the same beliefs, and it had to be written down for her peace of mind, that her wishes would be followed. That's the only real
No, that's very helpful. Get that clear in my
example
mind.
I can give.
And I'm sorry because I talked to nursing homes. They says, "Oh, we really should be having that document."
Yeah.
But I'm quite happy and confident to let my guardian make it. They know what I want, and in the end, they're going to
That's
make the
it.
call. And
That's
so I'm
it.
happy with that. But I could see there'd be individuals in that case, or even other ones, just say, "No, I'm going to dictate everything that happens. I'm going to have control over everything."
Yeah.
And
The
so you do that.
difficulty always, and it's the same with doing a will, well, certain types of will that are non-revocable, or that really try to control way beyond your death. I mean, often that they're not even really valid, but people attempt to do these things, and you just can't foresee what might possibly happen in the future, and what you would want in the future. You might say right now, if this happens, then I 100% want this to happen. Technology changes, we change.
Exactly.
So it's not something that I personally recommend.
No, and I think I wouldn't either under the same circumstances.
But of
just
course-
really got to find someone that you really trust and you communicate clearly with them,
Yeah.
so they know.
And unfortunately, sometimes there are people that don't have somebody that they can name.
Because my other
So
issue is I've seen where that person changes their mind. They said, "Oh yes, we're fine.
Yeah.
Won't resus. We'll do all this." But then when that circumstance actually comes up, they change their mind.
Yeah.
And even though
Yeah.
you've talked to them and agreed, but because of their reasons, they change their mind. But no, I can't do it. I can't do it. So
yes,
yeah,
yes.
that'd be it. But anyway.
Yeah, and something else, I read an article recently with another lawyer wrote an article about this, and I agreed with his point of view. He was saying types of things that I say, and his point was you can put something, for example, his example was you say in this advanced health directive, if I have a stroke, I don't want to be resuscitated, for example. And then that happens and the doctors get this document and they say, well, we don't recognise that word. We don't use the word stroke. We use another term altogether, so we're not going to recognise these wishes. For example, I don't know what would actually happen or how it would work, but it's just an example of...
I think in the end, we do some planning, we put the best that we can into place, and that's it. The thing I'm trying to avoid is not having anything in place, and it's a huge stress on everyone. No one knows what your wishes were, what did you want.
Yes.
You get caught up in the courts, whatever.
Yeah.
So, in the end, be as prepared as you can, and then...
Yeah. Ultimately, I think we're going to be relying on our doctors, our specialists, and their advice because they are the specialists.
Yeah.
But you do want to give somebody that power, because if they don't have the power, then you risk the possibility of the specialists not listening at all.
Right. Well, okay,
and you don't want that.
That's helped me a lot. I think so.
Yeah. So that's the power of guardianship.
Yep.
And that can be given to one or more people.
Right.
So this one is a little bit more flexible. The power of attorney is more rigid, if you like.
Okay.
So do you want to just go through the power of guardianship first? I'll take your instructions for that.
Sure.
Obviously, I've got your full name, address, etc. So my question would be, who would you name as your guardian?
As the guardian, now the first instance is my wife, Karen.
Yes.
So she's the first.
And I've got her full details. I'll just copy
That's
and paste those.
And then backup for the guardianship would be Matt, my son Matt.
Okay.
And that's mainly because he has the capacity to deal with. I think that where it would come in handy is, again, that if I'm not happy with a nursing home or it's not working out too good, then he would have that power to move me somewhere else. And so I trust that he would do a good job at that.
Yeah, and that's it. And sometimes you might have a very close relationship with somebody, but they might not necessarily be the right person. You might have 3 children. You love them all equally, of course.
Oh, yeah.
But some are going to be
just geared
more
up for. He's a human service worker and all that sort of stuff. So it just speaks a language.
Yeah.
So that's what makes it a bit more easier.
The power itself that you give, and that references the particular act and the relevant part of the act. Then there's the acceptances. So for you, there'll be your wife's acceptance and then your son's acceptance.
Okay.
So you will need to sign and in front of 2 witnesses.
Mm-hmm.
Your wife will and your son will. But it's
I just try to give people an idea of, kind of concepts. These are what's available, but you really need to check in your area.
Yeah.
But these are the things you need to be thinking about. And these are the reasons why you need to be thinking about it.
Yeah.
But
Yeah.
again, get professional advice in your location and suss that out.
Yeah.
And even if we're here in WA and we're talking to you and all that, but these videos stay up indefinitely type thing. So the laws could change.
Exactly.
So you still need to go back, regardless of when you saw this, to get the current
Definitely.
information, because the laws
Definitely.
change.
And I just had a client contact me yesterday asking me to review. She needed a letter by a lawyer for a power of attorney. Her mother has a bank account in the UK. So she sent me this through. They didn't recognise it, and they said, give us a letter from a lawyer saying that this is valid and then we'll accept it. Well, she sent it through to me and I looked at it and I said, I can't tell you that this is a valid document. Her late father had done it for her mother, who has now lost capacity, so she can't make a new one because that would have been the obvious thing to do. And I think he got it off a website or from a friend, and it referenced a very old, a 1919 Act from New South Wales. So, and when I looked up the Act, the relevant provisions had been repealed. And I don't know when they were repealed. They might have been repealed after the document was made, but obviously I couldn't help her in that case. I said, perhaps if you go to a New South Wales lawyer, they might be able to advise you on that, but it's just an example of, this, you can get a form and it looks very official, and it even had the old calligraphy type writing on the letterhead, but
Yeah, I've come across one person they shop to find the legislation that suits their purpose type thing. So
it's tricky business.
it is. If you want it to be valid, then you're going to have to just get it done.
Yeah. So, if you want to give me 10-15 minutes,
Yep.
I can get these documents drafted for you,
Okay.
and then I'll print them out for you to read and double check.
Yep.
And then when you're happy, I've got your will ready to go. Get those signed, and that'll be it.
Okay, sounds good. This is a completed document from Enduring Power of Guardianship. It's a very quick and basic document. Enduring Power of Guardianship just outlines the date, who my guardians are, and who I appoint, and who my substitute is, and their address. And then they have to accept it. So there's just an accept an appointment for my executor and my backup. I hope you found that informative, and that Enduring Power of Guardianship, or a similar document, maybe called something different in your locality, will be a useful tool in getting your affairs in order. I just wanted this video to be a guide to inspire you to start thinking about your estate planning and how much control you might want over the process. You may have to put more documents in place than just your basic will, and Enduring Power of Guardianship is one of those. Definitely check with your advisor of the context of what this document is. It could be a living will, it could be called something else in your locality. Just always check with an expert in your locality. Guardians make decisions on personal, lifestyle, and medical treatment. They do not make decisions on property or financial issues. You and your guardian must be at least 18 years old and have full legal capacity. You can appoint joint or substitute guardians. If you do not wish to have an enduring power of guardianship, the government will appoint a guardian where required. If you're new to this channel and like to know more, please hit the subscribe button, and most importantly, hit the share button and share this with everyone in your social network, whether it's social media, family, friends, anyone you meet who's over 50. If you want to give the gift of peace of mind and well-being in their retirement years. You can also follow me on Facebook, Your Journey Transitions, and my website, as I mentioned, yourjourneytransitions.com. If you want to be notified as soon as I release any videos, hit the notification bell. Until next time, this is Rick Ward, your guide to the retirement stages, wishing you an extraordinary retirement.
This is like a cocoon.
What comes out of a cocoon?
Butterflies.
Are butterflies beautiful?
Yeah.